Hello, I'm Robin Stewart and I'm a Senior Associate at Anthony Gold Solicitors. I specialise in property litigation and landlord and tenant disputes. Do couples living in shared accommodation always count as one household in HMO law? While the legal definition is clear, real-life relationships can blur the lines. So what is a household in HMO law? There are different legal definitions of HMO in different contexts. The one we're looking at in this video is the one found in the Housing Act 2004, which applies to HMO licensing and regulations and safety standards. A property occupied by just two individuals is never a house in multiple occupation. So a couple living together is not an HMO. However, if there are more than two people living in the same property and the occupiers make up more than one household, then the property will normally be an HMO. For the purposes of HMO and property licensing law in England, the term household is defined in section 258 of the Housing Act 2004. Essentially, two people are in the same household if they are in the same family. Couples can count as a family, whether legally married or not. Where two people are not related to each other, they will still count as being in the same family if one of them is related to one member of a couple and the other is related to the other. A couple means, according to section 258, persons who are in a civil partnership or are married to each other or who are living together as if they are civil partners or a married couple. The Act doesn't offer any further explanation about what this phrase means. So what does it mean to be living together as a married couple? At first, it seems obvious what living together as a married couple or as civil partners means. Unmarried partners living together in a durable relationship are likely to be living together as a married couple even if they choose not to get married. There were no binding court decisions directly addressing the definition of couple in the Housing Act 2004, but in other areas of law there has been more attention from the courts about what is meant by the words living together as a married couple. In immigration law, there are several routes to qualifying for rights to enter or remain in the UK on the basis of a relationship with an unmarried partner. In one appeal, the upper tribunal adopted a broad interpretation of a rule which required evidence that two people living together in a relationship akin to either a marriage or civil partnership, which has subsisted for 2 years or more. In that appeal, the tribunal accepted that 2 years could include periods when the couple lived apart, demonstrating that the concept of living together as a married couple or as civil partners is flexible and is not necessarily tied to traditional ideas about what marriage looks like. Government guidance to civil servants who make decisions relating to social security entitlement gives detailed advice on how to determine whether or not a couple are living together as a married couple. Here's how the guidance describes the nature of living together as a married couple. To be treated as living together as a married couple, the relationship has to be the same as that of a married couple. Marriage is where two people join together with the intention of sharing the rest of their lives together. There is no single template of what the relationship of a married couple is. It is a stable partnership, not just based on economic dependency, but also an emotional relationship of lifetime commitment rather than one of convenience, friendship, companionship, or the living together of lovers. If the evidence does not suggest that it is more likely than not that the relationship between two people has the particular emotional quality that characterizes a married couple's partnership, the decision maker should find that they are not living together as a married couple. That guidance for benefits decision makers considers the intention that the relationship be long-term is fundamental. The couple need to be two people who have the intention of sharing their lives together in the long term. So what does all of this mean to how we apply HMO law to non-traditional domestic arrangements? The Property Ombudsman, one of two redress schemes available to landlords and agents, published a case study in 2021 about a polyamorous throuple who were refused accommodation by agents. The agents told them that the local authority would see them as forming more than one household, making the property an HMO, and that this was not allowed at that property. The Ombudsman made no criticism of the agent's advice that the tenants would not have been treated as a single household, although they did not express any particular view on that issue either. However, the Ombudsman was critical of the unprofessional tone of some of the communications with the prospective tenants, and they supported that part of the complaint. This was an interesting case study, and agents might start to encounter this sort of issue more often. The Property Ombudsman case study does not attempt to offer any legal analysis, and we may be waiting some time for any authoritative case law on how to apply the Housing Act's definition of household to polyamorous groups of tenants. The Housing Act definitions of household and couple do not appear to include a throuple. Couple is defined expressly at section 258 as being 2 people, not 3. However, the Act does not expressly say whether a particular individual can be a member of 2 couples simultaneously. Section 258 can be interpreted in different ways, but if it's possible to be a member of more than one couple at the same time, the members of a throuple might be regarded as members of the same family, and therefore members of the same household. What should agents do about this? The only part of the complaint upheld by the Property Ombudsman related to customer service. Agents are a frontline service dealing with the public, and they should remain professional, even when confronted by lifestyles they find unusual. Where issues like this arise, the standard legal helplines might not be able to assist, and agents might need more specialist assistance. Anthony Gold participates in the Landlord Law HMO hotline service, which provides a quick route to specialist advice on any HMO issue. If you're struggling with an HMO case and you need legal assistance, then you can contact us on 0207 940 4060 or at anthonygold.co.uk.